Assalamualaikum warahmatullahi wabarakatuh. Hello everyone. Respected lecture of law and human rights Mrs. Indah Pangestu Amaritasari SIPMA and all my colleagues. Introduce me to Syarif Hidayatullah. On this occasion, I will present the human rights principle in international human rights law. From several topics, I will explain about the subject of human rights. In the subject of human rights, it is also divided into three parts. The first is state actor, stakeholder of obligation, and non-state actor, stakeholder of obligation, and non-state actor, stakeholder of right. Okay, I will explain from the first. The first one is state actor duty bearer. The state is the main subject of international law and thus is also a subject of human rights law. The definition of state does not change and is always identified the same in various international legal products and has four characteristics, namely fixed population, fixed area, governance, ability to conduct relation with other countries. A country that is a member of an international community acquires what is called in an international personality. Legal subjects do not have the same right and obligation automatically. International right and obligation involve and require status as an international personality, but getting international personality status does not automatically mean getting right and obligation as well. In the general understanding of customary international law, a country is considered to have committed a gross violation of human rights if the state does not try to protect or even negate the right of its citizens which are classified as non-derogable right. The state concerned has allowed the occurrence or has actually committed acts of international crimes, or serious crimes, namely the crime of genocide, crime against humanity, and war crimes, and or the state failed or did not want to hold state official accountable, perpetrator of the crime. The second, non-state actor duty bearer. Initially, international law was the law between states. However, it should not be forgotten. After all, the issue of protecting human rights is no longer the object of a sovereign state police. Therefore, this issue must be considered by country and other international institutions within the limits of the authority of international institutions. However, even the emergence of interstate organizations and various states like entities, such as the Vatican Sovereign Order and national liberation movements have changed the pretty character of international legal norms between states. It is possible to define a person or entity outside the state who has right and obligation arising from international legal norm as a subject of international law. In this case, the scope of the subject of international law become wider. For example, right and obligation under international law are established not only by interstate organization but also by their organs and responsible officials, as well as by a number of international economic organizations and non-governmental organizations. In this case, although they do not participate directly in the formation of international legal norms and in ensuring their compliance, uh, of course they can participate indirectly either in shaping international law, such as the International Law Commission, or in ensuring the enforcement of international legal principles and norms. Amnesty International, for example, they also resign rights and obligations that arise directly from international legal norms, even though they are limited by the existing scope. The third non-state actor right holder, in addition to the subject of human rights law as the owner of the authority and responsibility, the owner of the right is also considered a subject in international human rights law. The right holder here are, of course, individuals and groups of individuals, especially those categories as groups vulnerable to human rights violation. And first, individual in the development of discourse on the subject of international law today, there is tendency to see from state-oriented international law. Countries have begun to create norms that are more aimed at entities and other individuals to regulate the pattern of their relationship, legal person, including corporation in general, international non-governmental organization, responsible individual within an international organization, and the individual himself. And, and now the norms which aim to affirm the legal standing of individual and legal persons are not appeals directly to them, but are a transcription that requires impression through domestic legal norms. Individuals began to have a direct relationship with international law. The current level of international human rights law can be considered as a transition period leading to a new world legal order in which individuals will take on a more important role as subject of international life and possibilities and goods. Report of the Special Rapporteur at the 40th session of the Subcommission on Prevention of Discrimination and Protection of Minorities, which show that from a theoretical point of view and especially from a practical point of view, the individual is a bearer of international right and responsibility that are she has limited procedural capacity which is directly regulated by international law, and that the individual shall be considered at least as equal to the state as subject of contemporary international law. Some human rights treaties provide the opportunity for individual to file complaints directly before international bodies. Other such as the Genocide Genocide Convention and the Convention on the Elimination and Punishment of the Crime of Apartheid stipulates individual responsibility for states officials for the exercise of human rights protected by this convention as well as establishing the procedures 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 by which the responsibility can be applied directly by states practice to the individual. Older groups. Apart from individuals, the third generation of human rights also introduced so-called group rights, which were initially only uh, affirmative to the fulfill, full fulfillment. Oh, no, no. Outer groups. Apart from individual, the third generation of human rights also introduced so-called group rights, which were initially only affirmative to the fulfillment of economic, social, and cultural rights, but in their development also included civil and political rights because the two types or type of right are indeed iterated and influence each other. What is meant as a group here is handed progressive, following development in international human rights law discourse. However, there are at least the main groups that are recognized as subject of international human rights law, namely indigenous people, refugees, and minorities. Various international human rights treaties, as well as important court decisions, as well as the existence of specialist mechanisms with the United Nations in the form of committees, special rapporteurs, working groups, and independent expert confirm the extent of this. The groups are subject in international human rights law. Thank you. Terima kasih.